Hi folks, we're Tassless today, your pushback channel, and thank you for joining this radio, audio, no pictures live stream. In this essay, I'd like to talk about the application of ideological law and how, as distinct from factual or evidence-based law, and how this is radically, indeed substantially altering not only how the law is applied, but it's affecting due legal process and down to the basic levels of which cases and for what reasons the justice departments and departments of prosecution and so on, to what extent they'll pursue cases, and if tort cases being brought by not by the state but by private groups, for example NGOs and so on, how the bar is very, very, very much lowered for them to be able to bring legal actions in not only lower courts but superior courts as well. It's radically transforming what the Justice Department is meant to do, is doing, and indeed has been doing, and of course legal outcomes as well are affected by this. Now, I think just about every law school in the Western world is churning out lawyers who are being taught. Remember, there's very much a lower IQ crowd of law. If you wanted to get into law, certainly when I graduated to university, if you wanted to get into law, you needed like a pretty good, you had to, and this is in a strictly pass or fail type environment, you had to have a pretty good pass, like 75% plus, that sort of thing. And which only a small number of people, of course, were getting back in the day, again, in a strictly merit pass or fail system. But today, people that are being affirmative action through junior high school, affirmative action into senior high school, affirmative action into college, affirmative action into law schools and so on, then it's a very different mix of people. As I've mentioned before, the gender studies type structure of college education and examination and testing and so on, that gender studies model has been distributed out now amongst pretty much all courses, even some STEM courses, so that the low IQ, weak student that wouldn't have a hope of passing a proper exam will be given or offered a question and think, to what extent has the law affected black lesbian women? And they can then answer that. That's their exam question. They can get a law degree based on that. So we need to understand there's a very low IQ cohort of lawyers, a very low IQ cohort of lawyers are making up the majority of law students today. Now, the best and the brightest may go into private practice and so on, but given there's such a large cohort of ideological lawyers, low IQ ideological lawyers now, they're the ones that are in the NGOs, legal aid departments, departments of prosecution, public defenders, and so on and so forth. So they're very much the majority now in those areas. And you can sit down with the lawyers from, say, a Department of Prosecutions, and you'll be lucky to find even a single lawyer in there who is not an ideological activist and has not taken the view that the law now exists, that the whole legal system, the framework of law now exists to reshape and restructure society along ideological lines now. So the evidence and the law and the facts and things like that kind of don't really matter anymore. If they're useful to the ideological intention underwriting it, then sure, then they'll use the facts. But if the facts don't exist, then they kind of don't really care. They'll just fill in the gaps with ideology. That's how bad things are today, in my view. And just to follow on from that, it was interesting how many cases that how many arrests the police made, and I've mentioned this before, how many arrests the police made about the Palestinian marches and the very manifestly anti-Semitic utterances and statements that have been made, refusal from the crowd to move on when ordered to do so by police, flagrant acts of trespass, and so on, again refusing the directives from, say, college or university authorities to say, hey, you're trespassing, here's a notice, you have to move on. and also the multiple deadline. You've got 24 hours to move, then it's another 24 hours, then another one, then it's 7 days, and then the police are called after a gazillion requests to move on, and they still don't. Now, for those that are arrested for acts of trespass, and again refusing police directives, all reasonable stuff, they're arrested by that. I was looking at the amount of those people who are then prosecuted by the state. Now, his one district attorney, this is in the US, was it's a black lady, was saying that they're not going to pursue any of those cases because they don't have enough evidence. And as she was talking about it, and her department's issued some press releases to cover it, they effectively said that in order to prosecute these people who are in flagrant breach of the law and trespass, video evidence, it's dead. They're dead to rights. The case is already made, police body cam and all sorts of things. And yet this particular district attorney is saying, no, we're not going to pursue any of these cases because we need to meet an incredibly high burden of proof. So normally you need 2 witnesses for example, 2 witnesses is enough. But no, we've decided that we have to have 10 million witnesses for each accusation. We haven't got 10 million witnesses. We can't meet the burden of proof. We have to let them go. So they put upon them, I mean, it's not 10 million, I'm using that to illustrate the point, but they're placing upon themselves an astonishingly high burden of proof that they must meet. We can only prosecute these people if we meet this incredibly high burden of proof. We don't meet it, we have to let them all go, no prosecution. So all of these people, these flagrant lawbreakers who've broken multiple laws and not only acts of trespass but other laws, and again refusal to accept a police directive, they're let go. They just walk out, and that's it. For some reason the anti-Semitic comments of kill all the Jews and that sort of thing, that's no. Oh, well, they didn't really mean that. Hey, why would we want to bother people over that? But if it's a straight white male that does the same thing, then suddenly a very low burden of proof is more than enough to drag his ass through court. Now, remember the courts here, the process is as much a punishment as anything else. The legal harassment, police coming around your door and dragging you off, and SWAT teams this, and so the cost of lawyers, cost of court filing fees. You'll be facing an activist judge who'll make life as difficult for you as possible. Your evidence will magically disappear and go missing, whereas other evidence that you haven't seen and know nothing about will magically appear in the court, and it's too bad for you. And all sorts of breaches in due legal process will occur. So let's just have a look at this in the wider sense. There's a straight white male Christian man who's praying outside of a abortion clinic, for example, and there's a SWAT team, body armor, the whole 9 yards, kicking the door down to the guy's place to arrest him. Now, he could have just sent a message via his lawyer or said, look, please report to police station X, or because we want to interview you. I mean, they could easily have done that. It wouldn't have been a problem, and the guy would have dutifully turned up. He's a good, upstanding, law-abiding citizen, so that wouldn't have been a problem. But no, we've got to have a big raid. This guy, because he prayed somewhere near an abortion clinic, and that requires a whole SWAT team. So they're out to show, we'll show these bums his boss, and then goes through a long prosecution process, or going after a Christian baker that doesn't bake a cake, or bakes the cake but doesn't put LGBTQ writing on the cake, I think was the issue there. So just because you don't ice a cake with LGBTQ messaging, you have to be dragged through the courts for years. So clearly we're not talking about the law or breaking the law or justice or facts. We're not talking about any of those things. We're talking about ideology. That's what we're talking about here. And there's a stark difference between the ideology, between the evidence bar that's needed to bring certain cases to court. So if it's against a straight white male, Christian in particular, the evidence bar is very low. You don't really need any evidence. Just drag that motherfucker into court, because you know that the process itself will be the torture. And if the guy gets off, well, who cares? He's been tortured by the process, bankrupted by the process. So you've still punished him anyway, even though he didn't go to prison. But when you get real lawbreakers, whether it be Antifa, Black Lives Matter, the Palestinian marches, and all that sort of stuff, when you got actual real lawbreakers, caught on camera, evidence, evidence that's absolutely 100% good quality evidence that you could easily use to prosecute them, climate change people, protesters, and so on. It doesn't matter. The very, very few that do get brought to court, somehow magically an activist judge is given the case to hear, who just lets them off. It's all right. No, don't worry about this. Or gives them some bullshit $50 fine, and they walk out the door and go straight out to be an activist again. And just looking at, not only in Australia or the US or Canada, Britain, and so on, they're typically these activists are prosecuted 3 or 4 times, as in dragged into court 3 or 4 times before they're given any prison time. And even then, it's like 6 weeks or something now. Whereas, you look at the guy that prays outside the abortion clinic. The second time he did it, he got 5 years in prison. Excuse me, what's going on? So what we're looking at here is activism, legal ideological activism, a number of degrees and planes and dimensions here. The first is the decision to prosecute. If there's a he said, she said rape case with no physical evidence whatsoever, no DNA evidence whatsoever, the state will still take the case up and put vast resources into it. So they're quite happy to the lowest of the low bar of evidence, because it's an ideological issue. It's right on the gender, race type fault line, gender hustling, race hustling type fault line. So they're very inclined. So, well, here's an opportunity to reshape society, to punish, because we know that really all straight white males are rapist Hitlers. So we just randomly will pick any one we can for any reason, and that's like we're fighting back against this sort of wall of Hitlers. And so they think they're doing sort of great work. They're morally superior. It's a moral issue, and so on and so forth. Whereas the climate change activist that breaks the law flagrantly, it's on camera. They've got all the evidence, more than enough evidence to make a prosecution and put the person, in prison, or fine them, or give them a good behaviour bond or something like that. In spite of having all this, we won't bother with that. And they'll use all sorts of bullshit and lies, saying, well, we don't have enough evidence, when of course they do. So this very malleable burden of proof that they play around with in order to justify it is nothing more than ideological nonsense from people who've been low IQ flunkies who've been ideologically brainwashed. But at the core of all this is their belief, which is very much a belief they cling to, is that the job of the law today isn't to punish criminals or people that commit crimes. It's to punish people for ideological crimes and wrongthink, and to use the power and resources of the state to do so. And they're unabashed, unapologetic by this. This is what they've been trained to think. They're low IQ people to begin with. And so this is their mission, and they think they have an absolute right to do it. And if you say they don't, that means you are Hitler. You've been with Tacitus today, your Pushback channel, and thank you for listening.